An extraordinary escalation this morning between President Trump and the federal courts. The Trump administration appealing overnight after a judge threatened criminal contempt against them, saying officials ignored his order to turn around deportation flights headed to El Salvador last month.
A judge says there is probable cause to hold the Trump administration in contempt.
Trump is absolutely lashing out right now as Judge James Boasberg just dropped a bombshell that has the entire administration panicking. And I mean, this is devastating. Judge Boasberg, the chief judge of the U.S. District Court for the District of Columbia, is no longer just criticizing the administration's deportation tactics. He is actively moving toward possible criminal contempt against Trump's own team. On December 8th, Politico reported that Boasberg escalated his contempt inquiry over the Alien Enemies Act deportations, finding that the administration's declarations about flights to El Salvador were cursory and demanding sworn testimony from senior DOJ lawyers and DHS officials about what actually happened and who authorized it. This is not a policy disagreement being litigated through normal channels. This is a federal judge investigating whether administration officials broke the law by ignoring his direct orders. And here's what makes this absolutely catastrophic for Trump. This isn't just some liberal activist judge making noise. This is the chief judge of the D.C. District Court, one of the most important courts in the country, and he's conducting what amounts to a criminal investigation into cabinet-level officials. But real quick, before we get into this, let's be honest, you can't really trust mainstream media anymore. That's why we built John Brown's show to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, please subscribe, because you might think you are, but aren't. Your subscription actually matters here. All right, let's get into what actually happened. The contempt probe centers on deportation flights that continued after Boasberg issued an order halting them on March 15th. The administration's defense that the order only applied to planes still in U.S. airspace has been treated by Boasberg as exactly the kind of technical evasion that suggests willful disregard rather than good faith compliance. Think about what that means. A federal judge issued an order, stop the deportation flights, and the administration kept flying people out anyway, then claimed the order didn't apply because the planes were already in the air. That's not compliance. That's defiance dressed up as technicality. And Boasberg is calling it out. Now let me bring the receipts on why this escalated. CNN reported that Boasberg expanded the criminal contempt probe specifically because Homeland Security Secretary Kristi Noem failed to provide adequate answers about who approved deportation flights for more than 100 Venezuelan men after his order was issued. Failed to provide adequate answers. That's judicial language for stonewalling. When a cabinet secretary can't or won't tell a federal judge who authorized flights that violated a court order, that's a massive problem. And Boasberg's response was to expand the criminal investigation, not just ask for more information, expand the criminal contempt probe. That means he's treating this as potential lawbreaking that requires formal investigation. Share this video with everyone you know, because here's what makes this different from normal executive judicial friction. When a federal judge says a cabinet secretary has failed to provide answers and responds by expanding a criminal investigation, the stakes have escalated dramatically. We're not talking about policy debates. We're not talking about legal interpretations that courts work through over time. We're talking about a judge investigating whether officials committed crimes by defying his orders. That's criminal contempt. That carries real consequences, sanctions, fines, potentially even jail time for the individuals involved. Notice what the investigation focuses on. The administration's use of the Alien Enemies Act, an obscure 1798 statute designed for wartime emergencies. Trump's team has been using it to justify rapid deportations of Venezuelan migrants without normal procedural protections. And Boasberg has been skeptical from the beginning. He described it during earlier hearings as having frightening implications. That's not mild judicial concern. That's a judge saying this legal theory is dangerous and potentially unconstitutional, and his skepticism has only deepened as the administration has responded to his orders with what he characterizes as evasion and stonewalling. Now let's talk about what happened after the March 15th order. Boasberg required the administration to halt certain deportation flights, pending further review of whether the Alien Enemies Act could lawfully be used the way the administration claimed. Pretty straightforward. Stop the flights while we figure out if this is legal. But flights continued despite the order. The administration argued that the order's geographic scope didn't reach planes already en route. And Boasberg has treated this argument as bad faith parsing designed to frustrate rather than comply with judicial authority. Think about that framing. Bad faith parsing. That means he believes they deliberately twisted the language of his order to avoid actually complying with it. That they looked for loopholes instead of following the clear intent. That's the kind of conduct that leads to contempt findings. Make sure you're subscribed to John Brown's show, because here's what the December 8th escalation means. Boasberg concluded that the administration's written declarations about the flights were cursory, meaning they failed to provide the detailed information he had demanded. So his response was to require sworn testimony from senior officials. Testimony that cannot hide behind the vagueness of written submissions crafted by lawyers to reveal as little as possible. The officials being called to testify will have to answer specific questions about the chain of command, about who gave orders and who received them, about who decided that flights could proceed despite a federal court order requiring them to stop. Those answers will become evidence in determining whether contempt occurred. Share this with everyone, because the focus on Secretary Noam reveals Boasberg's determination to get answers from the highest levels. He's not letting responsibility be diffused throughout the bureaucracy. He's demanding that the cabinet secretary explain what happened. And when she failed to provide answers, he expanded the investigation. Cabinet secretaries are not accustomed to being treated as potential defendants, but that's effectively what the contempt probe creates. Officials who may face personal legal consequences for their roles if a judge concludes they violated his orders. Notice the standard Boasberg has invoked: willfully disregarded. That's the classic language of contempt analysis. It suggests a judge who is not merely disagreeing with executive policy, but who is preparing to hold individuals personally accountable for defying judicial authority. Contempt requires more than mere non-compliance. It requires knowing and intentional disregard of judicial authority. The administration's defense has been that it complied with the letter of the order as it understood it, that the geographic interpretation was reasonable even if the judge disagrees. But Boasberg's escalation suggests he is skeptical of this defense, that he believes the evidence may show officials knew the order was intended to stop the deportations and proceeded anyway. If sworn testimony confirms this, the path to contempt findings becomes clear. Now let me walk you through what else is happening simultaneously. At the same time the contempt probe was intensifying, separate rulings from California continued to hammer the administration's use of military forces for domestic law enforcement. Back in September, a federal judge ruled that Trump's deployment of National Guard and even Marines to Los Angeles to police protests violated federal law, including long-standing prohibitions on using the military as domestic law enforcement. Bloomberg Law and other outlets covered the ruling as a significant rebuke to the administration's theory that it could deploy troops essentially at will to support immigration enforcement. Think about what that ruling addresses. Trump deployed National Guard and Marines to police protests in Los Angeles, and a federal judge said that's illegal. That violates the Posse Comitatus Act that restricts military involvement in civilian law enforcement. The judge rejected the administration's theory that immigration-related protests constituted the kind of emergency that would justify military deployment, found instead that the administration was trying to use troops for purposes Congress never authorized. Share this video, because here's what the combination of these rulings creates. The contempt probe over deportations and the troop ruling paint a picture of an administration being checked on multiple fronts. Judges are saying you can't use military forces domestically this way, you can't deport people using this legal theory, and you definitely can't ignore court orders when we tell you to stop. That's judicial pushback against what some have characterized as an imperial presidency that does not recognize the limits Congress has established on executive power. And here's where Trump's response reveals everything. The Justice Department's response to the escalating contempt probe shows just how seriously the administration is taking the threat. On December 12th, the New York Times reported that DOJ asked the appeals court to kill the contempt inquiry entirely, seeking to shut down Boasberg's investigation before it could produce the sworn testimony and findings that could expose officials to sanctions or criminal referrals. Think about what that request means. This is not the confident response of an administration that believes it acted properly. This is the defensive response of an administration trying to prevent a judge from obtaining the evidence he needs to determine whether laws were broken. If they had clean hands, if officials had complied with the March order, if testimony would vindicate their actions, there would be no reason to seek termination of the investigation. The request to shut it down suggests instead that the administration fears what sworn testimony might reveal, that getting officials on the record under oath about who knew what and who authorized what could produce findings that damage the administration legally and politically. Notice what Boasberg has been saying throughout these proceedings, language that signals serious concern. He's described the administration's use of the 1798 Alien Enemies Act as having frightening implications. He's explicitly considering whether officials willfully disregarded his orders. That phrase, willfully disregarded, is not casual language. It's the specific standard for contempt. It means Boasberg is preparing to hold individuals personally accountable for defying judicial authority. Share this with everyone because here's what the personal legal exposure means. When cabinet secretaries and senior lawyers know they may be called to testify under oath about their roles in controversial actions, when they understand that their testimony could be used in contempt proceedings that carry real consequences, they become more cautious about executing aggressive orders. The deterrent effect extends beyond the specific officials being investigated to everyone in government who sees what's happening and realizes they could be next. This is how judicial accountability is supposed to work, creating consequences that shape behavior even for officials not directly subject to investigation. Now let's talk about what Trump has been doing in response. He's followed the familiar pattern, attacking judges as partisan opponents, dismissing rulings as the work of radical activists, expressing confidence that appeals will vindicate his positions. He's been absolutely unloading on Truth Social, calling Boasberg an out-of-control nutjob, saying the judge is crazed in his hatred, claiming this is all politically motivated. But here's the problem. The pattern of escalation from the judiciary suggests that these dismissals are not being accepted by the courts themselves. Boasberg isn't backing down because Trump attacks him. He's escalating the investigation, demanding sworn testimony, expanding the criminal contempt probe. That tells you the judge believes the evidence warrants this extraordinary response. Make sure you're subscribed because the political implications are massive. Having a federal judge openly investigating whether administration officials defied court orders undermines the narrative of legal vindication that Trump has been promoting. Trump claims that all legal actions against him are politically motivated, that he's done nothing wrong, that courts ruling against him are partisan activists. But when a respected chief judge escalates a criminal contempt probe, when he demands sworn testimony because written answers were inadequate, that contradicts the vindication narrative in ways that partisan rhetoric cannot overcome. The investigation exists regardless of what Trump says about it. And its existence suggests that the conduct it examines is serious enough to warrant this extraordinary response. Think about what happens if Boasberg concludes that officials willfully disregarded his order, if he issues contempt findings. The question becomes whether those findings will be accepted and what happens if they are not. The constitutional system assumes that all branches will accept judicial authority as legitimate, that contempt findings will produce compliance rather than defiance. If the administration responds to contempt findings by attacking the judge and refusing to accept consequences, the assumption that makes constitutional government possible is tested in ways that could produce genuine crisis. Share this video, because here's what the appeals court battle means. The question of what happens if the appeals court grants DOJ's request to terminate the investigation raises concerns about whether the judicial check on executive power can function when the executive branch seeks to prevent investigation of its own conduct. Courts can only enforce accountability if they can investigate, if they can demand testimony, if they can gather the evidence needed to determine whether laws were violated, An executive branch that successfully uses appeals to shut down such investigations before they can reach conclusions would effectively immunize itself from judicial accountability, creating exactly the blank check that judges have warned about. Now let me bring the receipts on what this means for immigration enforcement. The contempt probe affects the viability of the Alien Enemies Act strategy the administration has been pursuing. If judges conclude that administration officials broke the law in how they implemented this approach, if contempt findings create personal liability for those involved, future officials will be reluctant to participate in similar operations. The chilling effect on aggressive enforcement could reshape how the administration pursues its immigration priorities. Not because it chooses moderation, but because courts have made aggressive tactics legally dangerous for the individuals who would have to carry them out. Notice what the domestic militarization concerns reveal. The troop deployment ruling addresses fears about what kind of executive power Trump is trying to establish. Critics have warned that the administration is building a quasi-paramilitary presence, using National Guard tactical units and deputized local forces in ways that blur the line between military and law enforcement. The judge's ruling that this approach violates federal law represents judicial pushback against executive overreach. Whether appeals courts uphold this ruling will determine whether the judicial check proves durable. The constitutional crisis language that legal experts have been using gains weight from the contempt investigation. Contempt proceedings are how courts enforce their authority when the executive branch refuses to comply voluntarily. If Boasberg issues contempt findings and the administration refuses to accept them, we're in unprecedented territory. The constitutional system breaking down in real time. The historical significance of having a contempt investigation into cabinet-level officials over potential order violations will be evaluated regardless of immediate outcomes. The investigation creates a record, demands testimony, generates transcripts that future historians can examine. Whether that record ultimately produces findings of contempt, or whether appeals or political developments prevent conclusions from being reached, the documentation becomes permanent. The bottom line is this: Trump lashes out as Judge Boasberg drops bombshell with escalating criminal contempt probe investigating whether administration officials broke the law by defying court orders. December 8th, Politico reported Boasberg escalated contempt inquiry over Alien Enemies Act deportations, found administration's declarations cursory, demanding sworn testimony from senior DOJ lawyers and DHS officials about what happened and who authorized it. Not policy disagreement. Federal judge investigating whether officials broke law by ignoring direct orders. Contempt probe centers on deportation flights continuing after Boasberg issued March 15th order halting them. Administration defended claiming order only applied to planes in U.S. airspace. Boasberg treated as technical evasion, suggesting willful disregard, not good faith compliance. CNN reported Boasberg expanded criminal contempt probe because Secretary Noem failed to provide adequate answers about who approved flights for 100-plus Venezuelan men after order issued. When cabinet secretary can't tell federal judge who authorized flights violating court order, that's massive problem. Boasberg expanded criminal investigation, treating as potential law-breaking requiring formal investigation. Criminal contempt carries real consequences, sanctions, fines, potentially jail time for individuals involved. Administration used Alien Enemies Act obscure 1798 statute for wartime emergencies. Boasberg described as having frightening implications. Skepticism deepened as administration responded with evasion and stonewalling. March 15th order required halt to certain deportation flights pending review. Flights continued despite order. Boasberg treated geographic argument as bad faith parsing designed to frustrate compliance. December 8th, escalation after written declarations cursory. Required sworn testimony from senior officials. Cannot hide behind vague written submissions. Officials must answer specific questions about chain of command, who gave orders, who received them, who decided flights could proceed despite court order. Answers become evidence for contempt determination. Focus on Noem shows determination to get answers from highest levels, not letting responsibility diffuse through bureaucracy. Cabinet secretary must explain. When she failed, Boasberg expanded investigation, creates officials as potential defendants facing personal legal consequences. Willfully disregarded is classic contempt language. Judge preparing to hold individuals personally accountable for defying judicial authority. Contempt requires knowing intentional disregard. Administration defense claiming complied with letter of order. Geographic interpretation reasonable. Boasberg skeptical. Believes evidence may show officials' new order intended to stop deportations proceeded anyway. Sworn testimony confirming this makes contempt findings clear. Simultaneous California rulings hammer military force use for domestic law enforcement. September federal judge ruled Trump's National Guard and Marines deployment to LA policing protests violated federal law. Violates Posse Comitatus Act, restricting military and civilian law enforcement. Judge rejected theory immigration protests constituted emergency justifying military deployment. Found administration trying to use troops for purposes Congress never authorized. Combination creates picture of administration checked on multiple fronts. Judges saying can't use military domestically this way. Can't deport using this legal theory. Can't ignore court orders. Judicial pushback against imperial presidency, not recognizing congressional limits. DOJ December 12th asked appeals court kill contempt inquiry entirely, seeking to shut down investigation before sworn testimony and findings expose officials to sanctions or criminal referrals. Not confident response believing acted properly. Defensive response trying to prevent judge obtaining evidence determining if laws broken. If clean hands, no reason seeking termination. Request suggests fears what sworn testimony might reveal. Getting officials on record under oath could produce damaging findings. Boasberg described Alien Enemies Act use as frightening implications, explicitly considering whether officials willfully disregarded orders. Preparing to hold individuals personally accountable. Personal legal exposure creates deterrent effect. Cabinet secretaries knowing may testify under oath about controversial actions. Understanding testimony could be used in contempt proceedings with real consequences. Become more cautious executing aggressive orders. Deterrent extends beyond investigated officials to everyone seeing what's happening, realizing could be next. Judicial accountability working. Trump attacking judges as partisan opponents. Dismissing rulings as radical activists. Expressing confidence appeals will vindicate. Pattern of escalation from judiciary shows dismissals not accepted by courts. Boasberg not backing down. Escalating investigation. Demanding sworn testimony. Expanding criminal contempt probe. Judge believes evidence warrants extraordinary response. Federal judge openly investigating whether officials defied court orders undermines legal vindication narrative. Trump claims all legal actions politically motivated. Done nothing wrong. Courts ruling against him partisan activists. But respected chief judge escalating criminal contempt probe. Demanding sworn testimony because written answers inadequate. Contradicts vindication narrative. Investigation exists regardless of Trump's rhetoric. Existence suggests conduct serious enough warranting extraordinary response. If Boasberg concludes officials willfully disregarded order issues, contempt findings question becomes whether accepted and what happens if not. Constitutional system assumes branches accept judicial authority as legitimate. Contempt findings produce compliance, not defiance. Administration, responding to findings by attacking judge, refusing consequences tests, assumption, making constitutional government possible. Could produce genuine crisis. Appeals court battle over DOJ termination request raises concerns whether judicial check can function when executive prevents investigation of own conduct. Courts can only enforce accountability if can investigate. Demand testimony. Gather evidence determining if laws violated. Executive successfully using appeals shutting down investigations before conclusions effectively immunizes from judicial accountability. Creating blank check judges warned about. Contempt probe affects Alien Enemies Act strategy viability. Judges concluding officials broke law implementing approach. Contempt findings creating personal liability. Future officials reluctant participating similar operations. Chilling effect on aggressive enforcement. Courts made aggressive tactics legally dangerous for individuals carrying them out. Troop deployment ruling addresses fears about executive power Trump trying to establish. Building quasi-paramilitary presence. National Guard tactical units deputized local forces blurring military law enforcement line. Judges ruling this violates federal law represents judicial pushback, executive overreach. Constitutional crisis language gains weight from contempt investigation. Contempt proceedings how courts enforce authority when executive refuses voluntary compliance. Boasberg issuing contempt findings administration refusing to accept unprecedented territory. Constitutional system breaking down real time. Historical significance cabinet-level officials contempt investigation over potential order violations evaluated regardless immediate outcomes. Investigation creates record, demands testimony, generates transcripts future historians examine. Documentation permanent. Boasberg investigation real. Sworn testimony being demanded. Consequences could follow. Contempt findings, sanctions, criminal referrals. Judicial accountability constitutional system provides when executive crosses lines. This story continues. Stay tuned.